Okay, great, thank you. I have all the cameras adjusted and we are now ready to go. So this next panel is going to be, actually the next two panels are going to be about artificial intelligence. So this panel is on the challenges of drafting and prosecuting AI patents, and it is another CLE hour. So there are materials on the panel page at the bottom that will support this, including some slides that prepared by Gosha that detail one of the examples that we're going to talk about. So if you want to look at that particular slide, you can get it online. So what I'd like to do is introduce our speakers here. And let me make sure the camera is on a good shot here. Just give me 1 second. Okay. So first, let me introduce the person who's going to moderate this panel is Chris Hannon. And Chris is a patent attorney, and he is from the USPTO. He works in the Office of Policy and International Affairs at the USPTO. I asked him to moderate this panel. I'm usually very selective about who I ask to moderate panels, but Chris does a fantastic job. And AI is in his portfolio at the office, at the policy office. So he is perfect for this job. So thank you for being here, Chris. Really appreciate it. Then next I'll introduce Gosha. How do you say your last name, Gosha?
Kulczycka.
Okay. So I will just go with Gosha, if that's okay. So, Gosha is like Kasia, our vice president, is from Poland. And she is now practicing in California, and she is new to Patterson and Sheridan. She's been there for 6 months, but she's been writing these types of applications for a number of years. So we're very happy to have you here join us today.
Thank you.
And you have a PhD in this too, right? So you understand it on a very deep level, which is great. And then last but certainly not least is Wen Z. And Wen is a partner at Global IP Counselors, and she does this and specifically for her clients. And you probably also know Wen because she has a vlog, and we push that out through the IPWatchdog feed, and we're very glad to have her in the IPWatchdog family. So what I'd like to do is let's if we can, in sort of rapid fire to get everybody going and familiar with what it is that we're going to talk about, why don't we start, and I'm going to go in the order I introduced you in, to get your initial thoughts when you hear drafting, the challenges of drafting and obtaining AI patents. What's the first thing that comes in your mind, Chris?
Disclosure issues, I think, for me. So for background, I was a patent examiner for 10 years before sort of going basically everywhere in the USPTO. Asked me if I worked there, I probably did. But yeah, I think disclosure issues are very, very challenging issue, especially when we talk about one of three classes of invention. And maybe I'll just take this opportunity to sort of launch into sort of a framework that I think is useful to talk about AI inventions in the sense that, on one hand, maybe on one end of the spectrum, you have core foundational AI models, right? So if anybody's familiar with AlexNet, which was a 2012 breakthrough when we really saw graphic processing units come into play, and sort of, they've always been used in convolutional neural networks for some time, but when that really took off, like that architecture, right? Integrating software, processes with particular hardware units, just that model, that architecture itself, I'd say that's sort of like a foundational model as one class of AI invention. Then maybe in the middle is something that I would term sort of like a use case of those foundational models. So taking that AlexNet, training it on image data and making sure that it runs at X% efficiency in identifying cats, right? That sort of applied use case would be the second category, and that's when I think you could really get into some disclosure issues when you're trying to prosecute an application. And then finally, I think we get into the Thaler, like Thaler v. Vidal, right? So DABUS, those sorts of things where you're using some machine learning architecture to get some patentable output that is maybe not contingent on the AI itself, but that output itself has some patentable characteristic to it. And so I know Wen actually had a great interview with Dr. Thaler on IPWatchdog. I hope you all saw that, because it's pretty interesting to sort of see, peeling back that layer, which I think a lot of courts around the world have always been challenged by, but to answer Gene's question directly without going too far off the reservation here, disclosure.
Great. Thanks a lot, Chris. Gosha, let's go to you next. When you hear this topic, what's the first thing that comes to your mind that you want to share with the audience?
First of all, thank you, Renee, and thank you, Gene, for inviting me for this conference. The conference is great. We all enjoy it. But in terms of AI, I think drafting patent applications in the AI space, I think the enablement and patent eligibility issues are the most important. It is a transitional period right now where actually many examiners are being trained in this space. And at the same time, there is an explosion of companies that either develop AI or take an advantage of, for example, generative AI. And I am in an office in San Jose, and almost every day there are several companies that pop up and just do AI. I have many clients who patent in that space, and we are just learning as we go. Patent eligibility issues, if I have a chance, I would like to talk about it with reference to the one of two Macro cases, Macro 216. Then I would like to mention the enablement issues. That's, again, is in Macro case, but that one is from 2020. Please keep in mind that Macro case does not have much to do with AI, but it's almost like a Bible or an encyclopedia how to address the patent eligibility and patent enablement issues. And at the end, there is always PEG, which is a USPTO procedure for patent eligibility. And I would like to refer to example 39 and take the best out of it for our practice for drafting patent applications in the AI space.
Okay, great. Thank you very much. So to wrap up this segment here and start before I kick it over to Chris to have your conversation, I would like to hear what the first things that come to mind that you want to share with the audience on AI challenges, drafting, et cetera.
So back in the good old days when everything was an apparatus or a method, capturing make, use, and sell was actually a much more straightforward analysis because you're writing claims to capture, make, use, and sell because that's how you protect the commercial value. But now with machine learning and AI, you're talking about systems a lot more, and you're also talking about methods. But to really grasp what is the commercial value and how to write claims to preserve that and to capture that and to preserve that during prosecution, it is a lot more difficult because design arounds are a lot easier. How computer storage could be modified is very easy. And I think to be able to ask really the right questions at the onset to be able to support you later on becomes a lot more difficult.
Mm-hmm. Okay, great. Thank you very much. So now, Chris, I will turn it over to you and let you have the conversation that you guys want to have. And I'm happy to, if you want to call me, I'm happy to give my thoughts as well. And we have a few AI experts in the audience as well. So hopefully you all will chime up and participate. Go ahead, Chris.
Great, thanks, Gene. And yeah, and please, invitation to the audience, right? If you have questions, please throw your hand up and we can weave you in here. So maybe one thing just to sort of also get my plug for the USPTO in here is I think hopefully many of you have been following the work we've been doing, especially around inventorship. So we've actually held a number of listening sessions with the public. We had a request for comment that sort of posed questions about how do we navigate these issues, because I guess we haven't really directly mentioned that yet, the inventorship. I would argue maybe that ship has sailed, right? So the Supreme Court denying cert and Thaler v. Vidal, we kind of know what the state of play is for inventorship. But I think there could still be some issues that we could discuss. But Gosha, I want to sort of turn to you first and just mention that, because we have, these needle in a haystack cases on 101 where we see some positive light as to what is eligible. McRow, you mentioned, and even the PTO has tried to give some guidance on that. Can you maybe offer some tips in regard to how we can navigate that issue of eligibility when we're talking about AI inventions?
Thank you for the question. in a way, we are very thankful for the PEG, patent eligibility guidance, especially the one from 2019 that outlines the process of how the examiners review the claims to determine whether the claims are directed to the patent eligible subject matter or not. That is very helpful, and that works, at least for me, very well. And if I have an AI case that is about a neural network, I cannot resist to use the PEG example 39, which is about retraining the network with actually false positives that have been determined for facial recognition in a first run. I can get to it maybe a little bit later in detail, but of course the PEG 2019 provides a great deal of guidance. But Macro 2016 is very often overlooked, at least by some, but it is still applicable to the artificial intelligence. And why? Well, one of the golden thoughts is from Macro is that just because the steps of, for example, a method claim in application is the steps are performed by a generic computer, by itself is not a determinative of whether the claims are not directed to patent eligible subject matter or are directed. Just that because the steps are performed by the generic computer does not mean that much on its own by determining patent eligibility. What matters, for example, is whether there are, for example, certain elements that contribute to uniqueness, to novelty, to patent eligibility. And in Macro case, there was that issue of the weights. And not just, the prior art was also about weights assigned to different morphing points. But there was this very unique, very novel approach for actually, I'm sure everyone knows the Macro case, but that's actually about synchronizing the facial expressions in animated characters to the sound that is being played. And the important aspect was to be able to synchronize the mouth movements, facial expressions to what the character is supposed to say. But the way the weights were organized and that everything was done automatically without guessing, that was something that made the case patent eligible. In contrast, the ways that it was done before was where actually the animator, the person who was doing the matching between the audio and the video, was doing that by hand. How that looked like. He adjusted those weights by hand. Yes, maybe he applied some kind of rules, but the majority of those steps was subjective. So the point I'm trying to make is that when we draft patent application, and that's I'm trying to address your question, Chris, now. When we draft patent applications, it's important to, and that was actually discussed in previous panels, disclose the details, all the embodiments, all the details, because you never know how later on down the road you would have to amend the claims to get over the patent eligibility threshold.
So in some sense, I think what I hear from that is, we see the European approach to eligibility is really we can look in and see, is there a technical effect, technical character to the invention? And I want to read the first Macro similar to that there is in fact, you're showing some technological advance to that, right? So I think maybe I'll ask you, would you agree with that? Do you think that that's a helpful tip to sort of, when you're drafting an AI application, to sort of avoid upfront any sort of 101 rejection that could be looming by really tying it to some technical improvement, some technical effect? Is that fair?
So technical improvement, I was actually going to do the next vlog episode on it. It's a very interesting topic. The way the Fed Circuit has approached technical improvement is very different from the USPTO. The Fed Circuit has approached it from a overcoming well-understood routine standpoint, whereas the USPTO is taking it from a more practical application standpoint, and they specifically say we don't want to make it a well-understood routine, a conventional question. They don't want the well-understood routine and conventional to absorb 101. I think that was really the USPTO's stance when they came up with the guidance. It was practical application. So it became a question of practical application, which I also believe is much more the right question to ask when you're talking about subject matter eligibility. The one thing I will say about technical improvement is if your invention has anything to do with safety or anything with safety or efficacy, you do want to avoid going into technological problems, because the full test is a technological problem for which there's a solution, you're offering an improvement thereof, because you could really go into the realm of products liability there. And you don't want your disclosure to start being used against you because, oh, you've talked about problems, you know, and somebody's gonna be like, well, how long have you known about these problems? Even if you're talking about, you know, oh, say that laser was slower, oh, how, is that why this thing blew up now? You know, so I almost kind of don't wanna lean in too much into technological improvements.
Interesting. Okay.
May I add something?
Please. Yeah.
Yes, that's a very good point. But in the situations where you actually can use the technical problem to technical solution approach, this might be something very advisable and recommended in the long run. Why? Because if that application gets prosecuted at the EPO, and many of them are. Many applications related to the AI space are actually prosecuted or sent or filed nationally at the EPO and then go in different jurisdictions throughout Europe. Overcoming the patent eligibility standard requirements at the EPO is quite challenging in comparison to what the standard is at the USPTO. It's maybe not such a simple comparison, but very often in an application, the EPO examiner is looking for technical problem, technical solution. Even during this conference, many speakers emphasized the importance of describing the problem, but not too much. Not too much. Don't do the whole essay and background and all the other things. Maybe that also supports your point, Wei. But having the technical problem somehow described in a specification and then the solution and different embodiments really helps you if your application gets prosecuted at the EPO. Another point I would like to make is actually the unified patent system. That at the UPC, Unified Patent Court, Unified Patent Court, it's really not know what kind of standard for patent eligibility they will use. The court is still evolving, the judges are still being trained, the offices are being formed, but there is a suspicion that they will inherit a lot of the EPO processes and procedures. Therefore, having patent applications in AI or any space that actually take into consideration the technical problem and technical solution approach may be beneficial in the long run.
Yeah, no, and I just, I raised the point just because the last panel, the key takeaways was, you got to be able to patent in every jurisdiction, right? So to the extent that, there is some parity amongst patent offices around the world, that's going to be beneficial, I think, for everybody. So let me sort of stay with you, Gosha, and think about, the examples that the PTO has put out, right? You mentioned example 39. Is there more that the agency can do in regards to sort of shining a light on some of these 101 eligibility issues around AI type inventions? Yes.
If you had a chance, I'm sure many of you had a chance to look into the example 39. The analysis, the example 39 is about retraining a neural network. It starts with a step where you use actually set of images that we know ahead of time depict faces. And the whole algorithm is designed to actually train the neural network to be able to to determine whether the photograph or picture indeed depicts a face or not. So it is a face recognition program. And the example 39 takes the set of images that are indeed depicting faces, then is generating a second set, and that is called a modified set of facial images. And the modifications include various distortions, the various rotations, resizing, and so forth. And the reason they are doing that is because many of the facial recognition algorithms known in the prior art were not able to accurately detect faces in the images that were somewhat distorted. So the example 39 provides an. Again, please keep in mind that that is just an example. It's quite possible that it's a hypothetical example suggested to the USPTO or by the USPTO attorneys to demonstrate patent eligibility issue. But back to the claim. So then we train the neural network based on those images that are indeed depicting faces. Then in combination with the set of images that are directed to modified faces. And we have a third step where we actually, the third set that includes the images that are actually not depicting faces. And we train the network and we get some results. Unfortunately, we also get a lot of false positives, which means there will be some images that during the training process are actually indicating that the image indeed depicts a face, but it doesn't. So example 39 provides another solution in which we retrain the network with all the four sets right now, meaning including the false positives, to reduce the number of false positives. Now, if I had a chance to talk with someone at the USPTO, if I were granted that permission, I would really appreciate a little bit more in-depth analysis of that case, because in following PEG procedure, prong 1 of step 2A, it's very, very succinct, I would say. They say, well, there is no, the claim is not directed to the mathematical equations because there are no mathematical equations. Great. But the next step is that it is not directed to the mental process, and that's because it's impossible for the human mind to perform those steps. And I am just thinking, well, if you had just few images and very simple neural network, theoretically you could do it in a human mind. And maybe I'm missing something in that analysis, but maybe not. So that would be one thing. And the last thing is that it's not directed to the economic process because there is no description or organizing human activities because it's not economic process. We would really, as practitioners, we would really appreciate maybe more examples or more guidance in terms of why retraining the network cannot be performed in a human mind, but training the network itself could. So maybe more examples, more ideas, more explanation.
So that's, I think a short answer, yes, we need to give more examples. When on 101, I mean, anything to add before we move on to maybe some of the disclosure issues that Gosha there kind of teed up in training?
No, I think example 39 is really great because they stopped the analysis at 2A, and you really, it's great because you have to usually to go through all the steps. It's like, oh, this will just stop there, so it's a good one.
Sure, yeah. Well, and so I think, as Gosha mentioned, like there's these aspects of training, right? So in some sense, when Gene asked me the question, I said disclosure, because I think that's a fascinating distinction between that first class of AI inventions where it's just some foundational architecture, some model, we can call it different things probably, but then you have that use case where you really have to bring in training data and, machine learning over time, right? The more information it has, the more phases of use, right? It's going to get smarter. It's going to improve itself. So how do you stay on top of that when you're drafting an application to sort of make those distinctions between the two? I feel like the core model, right? You disclose it, you put your architecture down, you have your drawing, you're done. The applied use case, though, gets a little bit more challenging. So I just want to ask you about that, and do you have any tips regarding those types?
Well, luckily, most of the time is we separate it into two different applications. When you have, say, a training case versus an applied AI case, they do tend to go into different applications. Then it does have its own problems because sometimes what you're confronted with is sort of they have not fully reduced some things to practice. So you really want to get your inventors to flesh out some ideas and everything, because sometimes, it's been the practice among a lot of companies is, you want to disclose as quickly as possible. But yet with these AI cases, you do, like with these examples, you need more data. You want to disclose a lot more because in the long run, that's much better for you.
Sure, okay. Gosha, any thoughts on training and sort of how you think through that when you're drafting an application?
There is so much to say and so little time. It's really a great idea to talk with the inventors and get to the gist of the invention, whether it is using the output of generative AI or providing complex input to the neural network, or actually designing the neural network or model or learning model. It's a good idea to know all the details and really be able to explain or describe all the embodiments in the application.
So we're going to peel the veil back on the planning behind this panel, but Gosha said, hey, can we talk about stable diffusion? And I said, well, is that really a patent issue? Because stable diffusion to me, it's a transformer model. You put in text, you get an image. And so that's when Gosha schooled me on the true ability of how folks are actually out there in the field using this. So Gosha, maybe could you elaborate on that a little bit?
Yes.
And so just maybe in case anyone's not familiar, like I said, stable diffusion is a particular type of model where it maps text to images and it can create novel images based on those textual inputs. So I'll set that groundwork.
Thank you. A very hot topic, at least at Silicon Valley. And many companies are actually patenting in that space. And the things you can generate are just awesome. On the internet, there is actually a demo. The first time I got exposed to that technology, which was years ago, I typed the text, Gosha in San Jose, and I got a bunch of images. None of them looked like Gosha. None of them had background like San Jose, but it was something. When you actually patent in that space, it's probably very important to make it clear what is unique about the input you provide, whether it's a textual prompt input or whatever, and what you do with the generated output. And from that perspective, AI is just a black box, because you are not claiming how the stable diffusion algorithm actually works. It just you provide, the beauty of the invention is how you generate the prompt for what you want to receive, and for what you want to have received the images, and what you do with the output, what is unique about the output.
So when you're trying to capture that, though, I mean, are there disclosure issues embedded in there? I mean, when you're using some third-party model to then claim something, can you talk us through that?
Yes. In our applications, we often describe the stable diffusion algorithm to some extent, but not to the point where actually the description of the stable diffusion is actually considered to be a part of the invention. We describe it as a tool, because it's just a tool, almost like using any other tool to do what you need.
Right, so it's like when you said before, like mostly system claims, but here maybe it's more of a case of like a method, because you're telling the public how to, your claim to train this particular generative AI system to produce some output, right?
Yes.
I don't know, any thoughts?
No, I really do have to look up this table.
Okay, yeah. No, you can spend a lot of time wasting your time making crazy images.
Yeah, that's a neat program.
This is society now. So, well, in that regard, I guess one of the things that always fascinates me really is the level of assessing the person of skill in the art. Now that we have AI sort of bleeding into every single technological endeavor that's out there, and I've heard people say different ways to sort of approach this. One is that we need a brand new standard for, an AI of skill in the art, which to me, I think I'm not sure I'm on board with that yet. But really, I think it's, I tend to believe that the current status of Section 103, say obviousness analysis, it can sort of keep pace with technological improvements. So if that is the case, just as we define a particular engineering degree with a X number of years in the field, maybe we have to say, okay, well, that field now has AI, so if we're talking about drug discovery, well, it's a particular degree with X amount of years experience, but also the ability to access this particular model. What do you think? Like, is there a need to sort of change to a new 103 standard beyond the person of skill in the art, or is there, do you think it can keep pace with that for obviousness analysis, or just any thoughts on that?
Oh, I've never been asked this. Oh, gosh. That's
I'm going to put you on the
really
spot.
Interesting question. I don't know. One of the things I asked Dr. Thaler, who I was shocked, by the way, who was willing to do an interview. I thought he would just ignore me. But, there was a lot of debate in AI space about AI inventorship going to the prompt writer. And so I asked him, I said, do you need a high degree of technical proficiency to be a good prompt writer and to generate good results? And he actually said, not really. You could be just a person with a curious mind to do that. Yeah. So I think, maybe we should, there was some assumption on my part that he wouldn't say that you would need some degree of technical proficiency. So I don't know if we need to update the laws, but I think we should, I don't know, maybe provide more guidance as to maybe it requires someone who's able to train, someone who's able to program, maybe be more specific as to what exactly is a person with ordinary skill in the art. Yeah, rather than somebody who's really good at writing prompts.
Right. Thoughts on the 103 issue? Do you think we need a new standard to sort of handle these AI inventions, or is it sufficient to sort of just meld the current person of skill in the art to include that AI expertise?
I think this is something to be determined. There is already a lot of prior art in the AI space, and from what I hear, many examiners, the USPTO, are very well trained in the AI and have access to wonderful tools that help them to build their knowledge base. And whether that, and I think that allows perhaps to view the standard in terms of anticipation and obviousness from this pretty much the same perspective as it is for other arts. It's just more about the details. But I'm not sure whether the rearranging the standard just because it is the AI space is really necessary, or we go that direction. I would be actually interested to hear what the USPTO thinks about it. There were those many questions that were presented to the USPTO. I'm just very curious how those questions are going to be answered.
Question to the moderator, I like it. So I think those questions were really geared towards the inventorship issue to a large extent. But I mean, as I sort of, my own personal view, not speaking for the agency here, but for Section 103, I would argue that all technological advancements over the years, no matter what they were, that always sort of gets rolled into the analysis. So, before, I don't know, we had the Large Hadron Collider, right? If we're going to do astrophysicists looking for particles, right? You could never do that type of work until you had that tool. But once you have the tool, you just have to build that into the analysis of, okay, what are we talking about? How are we going to assess whether or not this is inventive in some sense? And I don't think that AI personally is any different. It's just we have to wrap our heads around as a society, sort of, integrate it to our own knowledge base and make sure we feel comfortable with using these technologies. And I don't think we're there yet. I think there is still a lot of hype and such out there, but I can confirm that the USPTO is diligently and actively studying, these issues. Like I said, the inventorship issue is in some sense, settled in some aspects, but new questions of obviousness. What do we need, for examples, to disclose an invention, training data, and all of that? I see a hand, so I'm going to go ahead and turn to the floor.
Thanks. What do you weigh in terms of the factors that you consider for the patentability versus trade secret protection routes for AI? Because it sounds like, this discussion is focused on what's required to be able to get a patent in place on AI tools. But in other contexts, there are inventions that I deal with where what we would have to disclose is so far removed from what would be claimable in terms of the subject matter, just to get to enablement for the invention, that we start to lean into trade secret protection. So in this realm, how do you navigate that in terms of where you think certain inventions should rest?
It's a great question. Maybe when I'll put it to you
Yeah,
first.
it's hard.
Turn to Gosha.
If my client said we'd rather keep this as a trade secret, sometimes like I get it, you know, wouldn't push you to disclose for a patent sake because you might not be able to claim that, either you just disclosed it and it might not get you a patent, you know.
And you said that detail is important, so when
Yeah.
you start to get very granular, I start to worry that you're over disclosing your hand, and what you're going to end up with in terms of protection will be narrow.
Yeah.
And then you're sort of teaching more than you'd like.
Yeah, no, that's a big problem, and for sure, and I've had problems like that with algorithms. Should we disclose this algorithm? Should we just keep it? You know, and luckily the client said, "Well, we were going to publish a paper on it, so all right, then we'll disclose it." You know, so you made that easy for me. But yes, I guess sometimes I would say, you know, a lot of trading data you should just keep. Yeah, it may be determined to be a mental process. It may be determined to be a mathematical formula. That's all judicial exceptions. Sometimes maybe, but then you have a scant disclosure, and then it comes off giving off the impression of abstractness. You know, so you really, it's a big problem. I can't say I really have a solution to that, but I understand it when my clients say they want to keep it as a trade secret.
Gosha, how do you counsel your client?
Maybe we will turn it to
Oh, sorry,
Jean.
Jean.
Yeah, no, I want to jump in here too, because there's a couple things I want to say that are related here. I think across almost all patent law, but certainly in this area, that what people do is they try and play cute, you know, and it's like, well, I invented X, but we need to disclose it as if it's elemental P through Z, you know, and we're going to capture the whole world. And I think that a big part of all the stuff that's been going on with 112 and people talking about reforming 112 and being upset with some of the means plus function cases, which are, you know, now 7-8 years old, is this desire to try and protect stuff that they really didn't invent. You know, they after developed stuff. And if I had one opportunity to talk to somebody who wanted to get a patent in this space in particular, it'd be to say, okay, what did you actually invent? And if you want to get a patent on that and allow us to describe that and disclose that, then move forward. You know, but we're not going to get the elemental P through Z patent for you, because then it looks like it's abstract and you're not focusing on anything. And the other thing I wanted to point out, like, and when Wen mentioned the product liability issue, I don't know how many of you know, I started my career as a litigator. I did general litigation of all kinds, all sorts. And I can tell you with 100% certainty that people who do product liability are looking at your patents. And because that's what I did, you know, and we found stuff, admissions, statements, and not only in the patents, in the file history. You know, so you have to, there is an extremely delicate balance here in this space in particular, because you have the one-on-one concerns, and NFISH tells us how to get over that by explaining what it does better, but you can't do such a good job to fall into KSR problems or describe the problem so bad that now you're going to have maybe liability issues downstream. So you really need to navigate, and that, again, all in my mind points towards the direction of claiming and disclosing what you actually have. Now, to talk about Idris's question, you know, about the trade secret issue, I think the big issue that you have to bring up with the clients is, how are you going to use what you created? Did you create something that is a tool for you, you know, or did you create something that you want to offer as a service for others? And that is really going to dictate how I think you protect this, because I always use the example, you know, as it turns out, Uber is not a taxi company. You know, Uber is a data company, and they collect all kinds of data, right? And access to that data is extremely valuable. So I'm sure Uber's got AI stuff that they're working and to go through the data and understand different things. But are they going to offer that product to others for use, or are they mining their own data so that the data and the insights from the data become the product? And if that's the case, then I think you're going down a trade secret path, not a patent path.
I see a hand out there, but before we do that, just
Why don't we answer the questions? I will.
Sarah, yeah, please.
So when you were talking about the person of ordinary skill in the art in the AI space continuing to become more sophisticated, and you were preparing an AI application, where do you draw the line in terms of how much you have to disclose in order to enable the invention? Like you mentioned sort of like 3 classes of types of inventions. Do you make sure that you disclose the training at each of those types of classes, or do you consider that to be something a person of ordinary skill in the art would know how to do?
No, I think I can't provide official direction here from the USPTO, but just as a personal response to you, I think the answer depends, right? And so if that's the case, if you do have that middle class, right, where you're doing an applied use case of an invention, I think as long as if you're going to claim some effectiveness, right? So like image recognition, I can always, 90% of the time, if I use this model in this initial training set, I can get 99% of the time correct image identification. So if that's what your claim is to, then I think you just need to get the public to that state to enable disclosure for that purpose. Beyond that, though, if it's going to be continually utilized and it gets better, I think that's something else at that point. Does that answer your question?
Not sure. It's more about whether to include, like, do you have to include the training part of it, or just do you always include the training part when you're filing disclosure?
I think for a use case, I think you probably would have to just to enable it, and if you didn't do that. But I mean, to Gene's point, right, that's the new oil, right, is data. So if you have proprietary data that you don't want to actually, show anyone because that's somehow valuable to you, then maybe you are looking more at a trade secret to keep it on this topic. But if you do have a claim to say, I've got this new architecture, but not only is it just a novel breakthrough in computer science because it's this new architecture, but really it can do this, then I think you have to sort of show us how you trained it to do that, whatever it is. Image recognition, again, for the hacking example.
I do want to say, you don't necessarily have to disclose the training data. If you don't want to, which I would say you probably don't want to, you could focus more on what inputs you're gathering, at what stage, how you're doing that, and what variables you're acquiring over time, and then what outputs are generated. So you could speak more broadly in that sense, rather than getting specifically to the training data.
So like a system sense, right?
Yeah.
Input, output.
Right.
Mm-hmm.
Yeah. But sometimes the invention is going to require you to mention the training data. Sometimes.
Yeah.
It depends upon how granular it is and what part you're focusing on. But you're probably better off not doing that to the extent that you can. Because I love what you said, that the data is the new oil. I mean, it really, really is. And everybody in this room, I'm sure, knows, like, when you go to the grocery store and you type in your phone number or you swipe your card or whatever, I mean, you're getting 10 cents off the apple because they now know that you like apples. Somebody in your household likes apples, And that's valuable information. I mean, I can't imagine the dossiers that have been created on all of us that are out there. And it just depends upon what it is you're trying to do. And I wonder, and maybe this would be a good question for all of you. I mean, because we've talked about trying to predict the future and see where things are going. Do you think that the AI tools are going to be for sale? Take this tool, buy this tool, insert it into your servers, or are they going to be more services, or are they going to be a situation where everybody's going to develop their own so that it is secret? I mean, where do you see the future going?
It's a great question.
Go.
Yes, and in fact, I would like to answer that question in combination with the 2 previous questions. My specialty in computer science used to be computer graphics, virtual reality. That's what I did for General Motors for 12 years. And there was that phenomena, OpenGL. Procedures, programs, subroutines that were available to everyone. Now, what do we have now? OpenAI. There are already some programs that become available off shelf, and that answers the questions of this gentleman. The way I see it is that it's going to be a transition where certain, and this is, again, in my humble opinion, where there will be a transition to actually having certain tools and AI-related utilities available off shelf to everyone. And that would be probably free of charge and unlicensed, who knows. At the same time, in terms of training and where we are going with this, it really depends what the invention is about. If it is about the neural network, then it looks to me like you might have to describe what the training is about, how you train the model, what the learning model learned or knows. But if you are just using the generative AI, then perhaps the training data, how the network was trained, is not so critical. It might be interesting is the information what you put in to that network once it's trained, or briefly describe that it was trained on such and such data, but that's not actually the invention you are after.
Right.
What you are after is what you feed, what you provide, the prompts, the inputs, and what you do with the output.
Yeah, and if I could just jump in, there was somebody, and I won't say who it was. I mean, if they want to identify themselves, I don't even know whether they're here, but mentioned that, 10, 15 years ago, if you had used the term point of novelty, it would have been blasphemy. People would have jumped all over you, and it's like, what are you talking about? It's not the point, it's the whole of the invention, that sort of thing. But the reality is, whether we like it or not, it's all, today, patent law in America is all about the point of novelty. And I think that's what, Gosha, where you're going to when you're talking about what are you claiming? What's the invention? What did you do? And where's the unique part? What's the point of novelty that you're building this whole application around? And maybe it's how the ChatGPT is accepting our comments and internalizing them, and then searching through its database to come up with the answer, in which case the training isn't so important in that. The point of novelty may be the interface between ChatGPT and us and how they get, that sort of thing. But if the point of novelty is a neural network and how the neural network learns, really, really machine learning, boy, that makes it a little bit harder not to think about how you could enable it with some at least dummy data set disclosed. This is all extremely interesting. I mean, I'll shut up now and let you respond. Any of you want to respond to that?
Well, go ahead.
2 seconds. Excellent point. Because Stable Diffusion is actually utilizing about 5 billion of images scraped from the internet, claimed to be publicly available. How would you want to describe or disclose that 5 billion of images?
Right.
Well, and I think that goes to show like the need for licensing and just guidance on sort of how to construct those deals in between the actual model and the data that's out there. But so I want to stay in this vein of trade secrets and patents, because I think, and I'll elevate a little bit higher policy level here, but I think there's a bad narrative at times around patents and sort of what they mean. And I think that's wrong, especially in the AI context, because patents actually provide a window into disclosure. They can, by shining a light on what the technology is, they can allow folks to sort of see if there's some latent bias that may be in because of how it was trained, right? So if there was a particular training set that's claimed or integrated into the application, then we can use that as a society to say, aha, but see, this is a flaw in that architecture. You don't have that in like GPT-4. It's a trade secret. We don't know what it does, right? So there's already been some instances where employees have gotten reprimanded because they're putting sensitive information into those inputs, the prompts, and who knows what happens with that, right? There was the issue of Meta's Llama. They had a proprietary, trade secret protected model that actually got leaked out, and so then open source community ran with that, and they started to really catch the heels of ChatGPT-4. You had Google then release their, there is no moat memo, where they're concerned that, wow, well, we're going to have our lunch taken and eaten from us if we don't sort of do something. And, as a patent attorney, I looked at that. I was like, well, you guys know you can patent these things, right? And actually have an exclusive right to do this. So what are you doing? But I think there is a lot of value in the narrative around AI. And so please take this message and preach it to anyone that will listen, is that patents serve a very good societal function when we're talking about AI, transparency, and bias. And so, yeah, there's always the ability to trade secret protect these models, but what does that mean in the broader context of impacts on society? So I'll get off my soapbox and give Wen a chance to jump in here on this.
Yeah, I don't know. I'm actually very curious as to what the board to learn more about what the agency, what you think the biggest problems are with respect to AI. Is it the person of ordinary skill in the art issue? Does it have to do with inventorship? I assume you guys are thinking about making some changes.
Yeah, no, absolutely. So I think the inventorship work, and like Gosha mentioned, some of the questions that we asked the public, and part of that was, what happens when you have a contribution from a machine that, if it was a human being, it would have been a co-inventor, right? Mm-hmm. And so, again, Chris Hannon, speaking personally for his own self, I think the question premise is flawed, because for whatever artificial distinction someone could argue that it is, there's always going to be that difference between a machine and a human being. For whatever reason, we don't want to get too philosophical here, but I think that is the distinction, right? And so, how do we gauge when a machine actually elevates to that? And so that's why I was so fascinated by your interview with Dr. Thaler, is because when I was sort of tracking all those cases and the Davis cases around the world, there was a sentiment from judges that they were often, in reviewing that case, they said, well, we want to ask the question about, like, what did Stephen Thaler actually do? When he woke up that morning, did he hit the power button? Yeah. What was all the work that he did to put in behind the scenes to train it? So I know it's the quote is that, well, I didn't give it any particular objective, but I just let it learn everything, and then it started to put things out. How many garbage inventions did that thing put out before he looked at that fractal container and said, this is great, I'm going to patent this, right? Yes. So I think there's an element of that we never really get to examine.
Well, that's interesting, because if you look at what ChatGPT puts out, it's usually garbage, or it can be very useful if you ask it a specific question and it can find it on the internet,
right?
But if you don't ask it a right specific question for which the people have written articles about, or government has posted information about, or that sort of thing, it does struggle, and it kind of regurgitates your question over and over again at the beginning and then at the end. And it's probably getting better, but I can't imagine what it would take to get something useful in terms of being novel and non-obvious from that at this point. Because it's just seems to me to be, we're at the regurgitation stage.
Well, one point on that is, so in our listening sessions, at the West Coast listening session, we heard from Professor Mark Lemley, who gave this idea of, well, what if I have some germ of an idea and I put it into ChatGPT, and then it gives me some dependent claims that are, I hadn't thought of them, but I read them and that's a cool idea. So I think his idea was a inflatable car, I think is what it was. And so what the ChatGPT provided was, it's now a modular, construction of this thing. And so if you then go and you claim that, what is the result? Are you going to get dinged on inventorship at some point down the line? And I think there's one way you can look at it and say, well, no, because you started down this path of invention. Yeah, you used a tool, just as someone could use an electron microscope as a tool and get better information out of that process. But ultimately, it's our human intellect that recognizes and appreciates something for what it is, and whether or not it's going to be a patentable invention or not. And I think we shouldn't lose sight of that, because machine hallucinates, right? That's what we call it, hallucinations. Okay, it's garbage. Effectively, it's garbage. It doesn't mean anything. But we know that, and we can say this is not useful. There's no need to pursue protection on this. So I'll stop there.
Yeah, but the issue becomes, does the human rise to the level of inventorship, given the current laws of conception, just because they recognize that that's a patentable? They could distinguish between that's a good output, that's not. So that's the next question that you guys have to
there are more questions too, because we had an event here, and this came up during the AI event, and I think you were here, and people were saying that if the AI can't be an inventor, we know that, but do we? we know it can't be the only inventor. Okay, but if the AI is a co-inventor, that should change the entire analysis. Because as long as there was a human who is an inventor, they came up with a conception, and then if the AI added to that, then you probably do need to disclose that. And I don't know whether the patent office is going to have to figure out how. And right now, probably the best way to do it, the safest way to do it, is as making the AI a co-inventor. I think that's another issue you're going to have to face coming up.
So Germany sort of handled this, right? So when they were looking at the Dabas case, they sort of hedged and they said, well, you can't name it as an inventor, but you can actually list it alongside. So you can say Stephen Thaler aided by Dabas, right? So you can do something like that. But personally, I'm not keen on the listing machines, because machines change, right? Which version,
right?
Like at what point in training, like et cetera.
No, it's going to be messy and murky. But I don't think that the inventor aided by is the right thing, because aided by, we use calculators, we use computers, we use microscopes. AI is of a different sort. The microscope is not giving you any kind of conception. You're not going to put something in a claim because a microscope suddenly, it's because you interpreted what the microscope is showing you much closer. But with the AI, it's like maybe it's not there yet, because I think what it pushes out kind of creates your seeds churning in your head. So you still are the inventor, but we will have, whether it's a year, 5 years, 10 years, where the AI comes up with a conception that I would not have thought of that.
Yeah.
And that's the problem when
That's what Thaler was trying to present to you. It was a very unique case. What he was trying to.
And I don't know that I don't know that he could have presented it properly, because I don't know that the AI is there yet.
Yeah.
And that's the rub for me, is that how do we make policy in this space and sort of future-proof it so that we're not undoing things in the future?
Well, but you're not going. And see, that's the problem.
Exactly.
You're not going to be able to, because you're always going to be chasing.
It's always chasing it.
At least initially, because with this curve, the technology curve, it's not going up slowly. It's going to go up like this,
Right.
and then it will level off.
Yeah. Right.
Isn't this analogous to like biological science, where Alexander Fleming, threw something on an agar plate and discovered penicillin sort of by accident? So your inputs are kind of what you're throwing at the plates, and your output is the thing that worked. So you didn't conceive of the solution, you found it kind of by accident in that scenario, and that's the same thing that's kind of happening here in a lot of cases.
Right, and probably another way of looking at that is, if AI is just a particular application or invention in the AI space, is just to do things faster, quicker, more precisely, better, then there is really not much of inventive concept there. But if there is something that makes you think about, like the penicillin example, where actually something happened, the initiation was not by the human, but then it was actually because he recognized the properties of it, then that might be a right way of perhaps pursuing in terms of the inventorship issue at AI, ownership as well.
I think we're close to time, right?
Yeah, we have a couple minutes left to wrap up.
Yeah, okay, so why don't we do that? Maybe if in true IP Watchdog fashion, if we could start with you, Gosha, and maybe give the audience one key takeaway that you want them to remember from this panel.
Thank you. It is an area that is exploding right now. Many people are experimenting and working in that area. It's interesting to see what will happen. I see it as a trend toward the open AI and patenting the usage of it, but that may change.
When?
Yeah, again, about how the technology is developing so fast that we're trying to keep up. I would say that it's hard to say there's one takeaway other than we're trying to keep up as best as we can. But the questions just arise so quickly, and there's a lot to ask. But it's just a great debate. It's very interesting. It's always, I learn so much from everybody and what everyone has to share. I think we're all skilled in the art.
Right. Yeah. Well, and the PTO, I mean, my one point as moderator, I'll take the privilege, is definitely that we are actively watching all of this and sort of taking public comments into account. So keep sending us comments. We have a standing policy on that. So let's continue to do that, and we're going to hopefully get some clarity here.
Great. Well, thank you very much, guys. I appreciate that. It was a great conversation. And I also appreciate when you said when a couple times. I don't know, and I think that sometimes is the best answer that we have. And Gosha, I have to admit, I was embarrassed when we first started talking that you started bringing up Macro, and I hadn't connected Macro to AI, and it's so obviously connected. And what saved Macro to a large extent was they had at least pseudocode, or what could be interpreted as pseudocode in the disclosure. So if you are not willing to put that in your patents for AI, I think you got a real problem. But we're going to keep on this issue because it's going to change. We could do this panel next week and it would be different. So we will come back to this. Thank you very much.
Thank you.
All right, so we will have a 15-minute break, and then the last segment is ethics.